Hi, and welcome to today's podcast and video episode of Legal Scrubs. Today I want to talk about HIPAA. Recently, the Department of Health and Human Services Office for Civil Rights, which enforces HIPAA, took an enforcement action against a dermatology practice in New England. The reason for this enforcement action was that the dermatology practice was disposing of basically specimen bottles that had protected health information on the bottles, name of patient, date of birth of patient, date specimen was taken, by whom the specimen was taken, that type of thing. It had this information on the specimen bottles, and the specimen bottles were disposed of in a dumpster, unlocked, just in the parking lot of the dermatology practice. And apparently this had been going on. This is how the practice had been disposing of used specimen bottles for approximately 10 years. What happened in this case was that a security guard there found a bottle, I suppose, somewhere near the dumpster or in the parking lot, and because of that discovery, the practice did a breach notification filing with the Department of Health and Human Services that there had been a breach of the HIPAA rule, and the Health and Human Services Office for Civil Rights did their investigation and took the position that the method that the practice was disposing of these specimen bottles with the protected health information on the labels was a violation of HIPAA. Now, what happens in this kind of situation is that the practice is not required to admit liability or admit fault, but the parties, the government and the practice, enter into a settlement agreement, and the practice agrees to take certain corrective actions going forward. And also what happens is the practice has to pay essentially a penalty or a fine or a settlement amount in order to settle the HIPAA violation case. And in this case, the practice paid slightly over $300,000 as a penalty or fee or a settlement amount to the government because of this alleged HIPAA violation. So for 10 years or so, the practice was disposing of these specimen bottles the same way. There had been no problem, but then one bottle was found by the security guard. The practice filed a notification with the Health and Human Services, and the case started. And as a result, the practice had to adopt a policy, a written policy, had to agree to train its employees in the implementation of HIPAA practices with respect to disposal of specimen bottles, and had to pay this fairly hefty fine of $300,000, slightly more than that. So the big picture here, the big takeaway from this is it is crucial that a physician practice, take steps to ensure that it does not improperly dispose of anything, paper, specimen bottles, anything from their practice, from their medical office that has protected health information on it. Because if you do that, then there's a high risk of having disclosure of protected health information of your patients. And so in this particular one, this case with the enforcement case with the dermatology practice in New England, the government also, as part of its announcement of this case, published a copy of its frequently asked questions about disposal of information from a practice that has protected health information. Talked about electronic devices like computers or computer drives that might have it. Talked about things like specimen or pill bottles or anything like that that might have a label on it. It talked about paper in general that might have protected health information, and the takeaway from these frequently asked questions is that the practice has to take steps to not allow for the unauthorized disclosure of protected health information by doing something to destroy the material that has the protected health information on it before it disposes of it. For example, it could burn it, burn paper, could pulverize the specimen bottles to the point that the labels are not readable. It could, if it had electronic media, it could expose it to a high grade magnet that would wipe it clean, or it could override it with certain software so that protected health information is not obtainable. It does provide in these frequently asked questions, and it makes clear that if you have a practice that you don't want to take the steps yourself to eliminate the ability for someone to get this disclosure of protected health information by burning or pulverizing or pulping or doing something to the electronic media, you can have a third-party contractor to your practice take on that responsibility to get rid of, dispose of, specimen bottles, paper, whatever that has protected health information on it. But if you do that, you have to make sure that like in the case of specimen bottles, that you put it in an opaque bag of some type so it can't be seen, and to be delivered then to the vendor. And then you would need a business associate agreement with the vendor who's going to dispose of the protected health information that puts them on notice and gives them the responsibility of protecting the health information while it's in their hands. And so if a practice wanted to, if it didn't want to do the actual destruction of the protected health information when it disposes of materials like paper or specimen bottles, but would rather have a third-party vendor dispose of those materials, it can do that, but it needs to have a business associate agreement with that vendor so that the vendor is on notice that it has to take the responsibility for not disclosing and for protecting that health information until it is disposed of. So that's it for today. I hope this helps. Be sure that if you do have protected health information of your patients, that you take steps to not dispose of that material that has the protected health information in a way that would allow it to be disclosed. You have to take steps to make sure that the protected health information stays private and is not just thrown away into an unsecured dumpster, for example. All right, that's it for today. Today's episode of Legal Scrubs. We'll see you next time.